Okay, let's dive right in. Picture this. Someone dies because of something someone else did. Instantly, you have this big legal question, don't you?
Yeah, is it murder? Or maybe manslaughter? Or, something else altogether?
Exactly. It's a complex area, this landscape of criminal homicide in the legal system, and that's what we're exploring
We
today.
are. We're going to try and unpack the really critical bits, the elements, the key distinctions, the specific legal tests that separate one type of unlawful killing from another here in England.
And we're basing this deep dive on source material that's been made available specifically for educational purposes by the University of London.
Which is fantastic. They're a great resource for legal education. And yeah, we're really grateful they make this stuff accessible.
Absolutely. And also, this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
A big thanks to Sinorbit Academy for their support.
Definitely. And look, we know a lot of you listening might be using this for your studies. Maybe you've even got exams coming up quite soon.
Yeah.
So we just wanted to explicitly say good luck. Seriously, all the best with your exam prep and your future studies. We really hope this deep dive helps things click.
Yeah, absolutely. Our goal today is basically to take these sources, zero in on the most important bits, definitions, key cases, the law around criminal homicide, focusing on murder and involuntary manslaughter, and help make it clearer, easier to remember.
We'll highlight the crucial concepts, repeat important facts now and then to help with memory, structure it logically, to get you ready for those exams.
Sounds good. So where do we start?
Let's lay the groundwork. We'll begin with the elements that are common to all criminal homicide. Then we'll look closely at murder, what it is, and those really important partial defenses that can actually reduce it to voluntary manslaughter.
Okay.
And finally, we'll get into the different kinds of involuntary manslaughter, where the fault level required is lower than for murder.
Right. A solid plan. So the foundation first. What do murder and involuntary manslaughter share?
Okay, so both start with the same fundamental actus reus. That's the physical act, the conduct part of the crime. What's that core conduct?
It's the unlawful killing of a human being.
Right.
That's the bedrock, the critical difference, the thing that separates murder from manslaughter. That comes down to the mens rea.
The mental state, the level of fault.
Exactly. What was going on in the defendant's head at the time.
Got it. So the actus reus breaks down. A killing, an unlawful killing, and a human victim. Let's take a killing first.
Well, this fits the usual pattern in criminal law. It normally needs a positive act by the defendant. But both murder and one type of manslaughter, gross negligence manslaughter, can also be done by omission.
A failure to act when there's a legal duty.
Precisely. But a key point from the source is constructive manslaughter cannot be done by omission. It needs an act. Always an act for that one.
Okay, good distinction. Next, an unlawful killing. When is a killing lawful?
Well, it's lawful if it's genuinely accidental, no criminal fault involved, or if there's a valid legal defense like self-defense, used reasonably, of course.
And consent. Can you consent to being killed?
Generally, no. The sources are clear. Consent doesn't usually make an active killing lawful in the UK. You can't agree to be killed.
Right, and that was tested in the Nicholson cases, wasn't it? 2014, and then the European court in 2015.
It was. The courts basically said, look, there's no right to assisted suicide in UK law. It's such a huge moral issue, it's really for Parliament to decide, not the courts.
But it's interesting how different places approach it. Your sources mention Carter v. Canada from 2015.
Yeah, a real contrast. The Canadian Supreme Court did find a right to assisted dying based on their own human rights charter. Shows a real divergence, doesn't it? Different balancing acts between autonomy and sanctity of life.
But UK law does respect autonomy when it comes to refusing medical treatment, right?
Absolutely. If a competent adult refuses life-saving treatment, doctors who respect that decision aren't liable if the patient dies, even if not intervening leads to death.
The St. George's healthcare case is a powerful example. Operating against a competent pregnant woman's refusal was found unlawful.
It was. So you have this line. Actively causing death, even with consent, is generally unlawful. But allowing death by respecting a refusal of treatment is lawful. It's about active steps versus respecting a patient's decision. A subtle but crucial distinction.
Okay, and the third part of the actus reus, a human victim.
Straightforward enough. Criminal homicide protects living human beings. So, a fetus isn't protected by homicide law, though there are other specific offenses like child destruction. The victim has to be born alive, have an independent existence outside the mother.
And that interesting point from AG's reference number 3 of 1994 about injuring a fetus who's then born alive but dies later.
Yes. The court held that Generally, an intention to harm the mother or fetus doesn't automatically transfer to become the mens rea for murder if the child is born alive and then dies. You'd usually need a specific intent directed at the born child.
And just to clarify, withdrawing life support.
If it's done following proper medical procedures and guidelines, that's not considered criminal homicide. Covered elsewhere in the materials, but worth noting.
Okay, let's quickly recap those common elements. The actus reus for all criminal homicide is an unlawful killing of a human being. That's our starting point.
Right. Now, building on that, let's get into murder. This is where the specific mens rea becomes absolutely critical.
The old term is malice aforethought, but like you said, the sources say put that aside, it's confusing.
It really is.
Hmm.
You don't need premeditation. You don't need malice, like hatred, a sudden killing in anger, or even, tragically, a killing done out of misguided compassion, like in the Inglis case.
Where the mother kills her severely disabled son.
Yes, that can still be murder if the necessary intention is there.
So what is the true mens rea?
It boils down to this. Intention to kill, that's sometimes called express malice, or intention to cause grievous bodily harm, that's implied malice. Intention. That's the word.
And intention usually means it's your aim, your purpose, right? Death or GBH is your goal.
That's direct intention, yes, but the law also covers indirect or oblique intention. This is where death or GBH wasn't maybe the main goal, but the defendant saw it coming.
Saw it as a virtually certain. That's the key test, isn't it? From the Woolen case.
Exactly. Woolen, 1999. The jury may find intention. They're not forced to, but they may if they're sure the defendant knew that death or grievous bodily harm was a virtual certainty, barring some unforeseen intervention, and the defendant appreciated that this was the case.
This is so important for exams. How judges direct juries on this?
Absolutely. The sources stress this. For clear-cut cases, like the gangster stabbing in illustration 7.2, the judge uses the standard direction. Did the defendant intend to kill? If not sure, did they intend to cause serious injury? Simple yes or no.
But for those tricky oblique intention cases, where maybe the main aim was different, like throwing someone off a roof just to scare them, illustration 7.3, or that really stark example, throwing a child from a burning building, illustration 7.4.
Then the judge gives the special Woolen direction. They tell the jury they may find intention if satisfied that death or serious harm was a virtual certainty, and the defendant knew it. Keywords. When we find intention, virtual certainty, it's a very high bar. Higher than just highly probable.
And the jury looks at everything, right? Including motive. That's why in the burning building example, even with virtual certainty, the jury might decide not to find intention because the motive was clearly to save the child. Allows for common sense.
Exactly. So let's just repeat what level of harm needs to be intended for murder.
Intention to kill or intention to cause grievous bodily harm. Either one is enough.
Spot on. This was nailed down in Vickers back in '57 and confirmed again in Cunningham in 1982. Remember Cunningham? Hitting someone repeatedly with a chair.
Yeah.
The House of Lords said proving intent to cause really serious harm was enough for murder, even if he didn't specifically intend death.
Okay, and what exactly is grievous bodily harm? GBH.
The definition is really serious harm. Simple words, but powerful. It's up to the jury to decide if the harm intended counts as really serious. Importantly, it doesn't have to be life-threatening harm.
Just really serious, like the gangster smashing kneecaps example, illustration 7.5. That could cause death unexpectedly, and if he intended that really serious harm, it's murder.
Correct. Intending GBH is sufficient mens rea for murder. Let's say it again. Intending GBH is enough for murder.
But this rule that intending only serious harm is enough for a murder conviction, which carries that mandatory life sentence that's quite controversial, isn't it?
Hugely. Critics call it unjust, a kind of constructive liability, because the level of fault, intending GBH, doesn't quite match the outcome, death. The Law Commission actually proposed splitting murder into first and second degrees, partly to deal with this.
Yeah, it definitely makes you think about fairness, especially with that mandatory sentence. Is intending really serious harm truly the same morally as intending to kill? Something for you listening to ponder.
Right. Now let's shift slightly. What about situations where technically all the ingredients for murder, the actus reus and the mens rea, are there, but something else comes into play?
You mean the partial defenses?
Exactly. Successful partial defenses don't lead to an acquittal, but they reduce the charge for murder down to voluntary manslaughter. This avoids the mandatory life sentence, allows for sentencing flexibility.
And we're focusing on the two main ones, loss of control and diminished responsibility.
Let's start with loss of control. This replaced the old dealing with slow-burn anger from long-term abuse. Provocation didn't always require a sudden reaction.
The new law is in the Coroners and Justice Act 2009, sections 54 and 55. It requires a loss of self-control caused by a qualifying trigger. And, crucially, the Act explicitly says the loss of control does not have to be sudden, so that slow burn idea can still potentially apply.
But very importantly, killings done out of a considered desire for revenge are specifically excluded.
So what is loss of self-control? Is it just losing your temper?
No, it's more than that. The old definition from Duffy is still relevant, being so subject to passion as to make him or her for the moment not master of his or her mind. It's about losing mastery over your actions. As R.V. Goodwin showed, just being frenzied or acting disproportionately isn't enough by itself.
And if there's a big time gap between whatever triggered it and the killing.
That makes the defense much less likely to succeed, according to Dawes and Hatter. Suggests it wasn't a loss of control, maybe more like revenge.
Okay, the qualifying triggers. The new law is much stricter here than provocation was. Only 2 specific triggers count now.
That's right, only 2 under Section 55, first trigger. Fear of serious violence from the victim, either against the defendant or someone else. This often comes up in domestic abuse cases, like illustration 7.6.
And it can overlap with self-defense, can it? Like, if you claim self-defense but use too much force, think Clegg or Martin, Anthony, you might fail on self-defense but still argue loss of control based on that fear.
Exactly. The evidence might support both, even if only one succeeds. The second trigger is more complex. It requires things said or done which constituted circumstances of an extremely grave character. Any caused the defendant to have a justifiable sense of being seriously wronged. Point 554.
2 hurdles there. Extremely grave character and a justifiable sense of wrong. So, minor insults, nagging, crying babies, they won't qualify.
Precisely. It filters out trivial triggers. Think of Bowyer, the burglar. He couldn't claim a justifiable sense of being wronged when the homeowner insulted him during the burglary.
And there are restrictions too, right? Section 55(6).
Yes. You can't rely on a trigger. You deliberately incited yourself just to have an excuse to use violence.
And the big one, sexual infidelity. Section 55(6) again.
Yes, the law is very clear. Sexual infidelity in itself cannot be a qualifying trigger. If the loss of control is purely down to jealousy or possessiveness about infidelity, the defense fails. That was a deliberate policy change.
There was that Clinton case, Clinton, Parker, and Eben.
Yes. Clinton clarified things. Sexual infidelity cannot be the trigger on its own, but it can be considered as part of the context, part of the background circumstances when looking at other potential triggers.
So if the infidelity was revealed alongside, say, taunts or abuse that were of an extremely grave character and did cause a justifiable sense of being seriously wronged,
then the infidelity forms part of that overall picture the jury considers. But Dawes and Hatter later confirmed, just finding out about infidelity or a relationship breakup on its own generally isn't extremely grave enough.
Okay. And there's also an objective element to loss of control, section 54(1)(c).
Yes. Even if there was a loss of control and a qualifying trigger, the jury must ask, might a person of the defendant's sex and age, with a normal degree of tolerance and self-restraint, and in the defendant's circumstances, have reacted in the same or a similar way?
And circumstances there means things relevant to the trigger, like history of abuse, but not things that just make the defendant short-tempered or less able to control themselves, right? Like being drunk or having a personality disorder affecting self-control.
Exactly. Intoxication is specifically excluded by Asmelash, and Wilcox confirmed that even a mental disorder affecting self-restraint doesn't count for this part of the test. The law expects a basic level of self-control from everyone, judged objectively.
Procedurally, the defense just needs to raise enough evidence for the issue to be considered.
Yes, raise sufficient evidence. Then the burden shifts to the prosecution to disprove it beyond reasonable doubt. The judge makes the initial call on whether there's enough evidence for the jury to even consider it. And appeal courts, as cases like Dawes, Hatter, Bowyer, and Martin 2017 show, are generally reluctant to interfere with that initial judgment call.
Okay, that's loss of control. Now, the second partial defense, diminished responsibility.
This is under the Homicide Act 1957, Section 2, but significantly amended by the same 2009 Act that brought in loss of control. Its purpose is mitigation reducing murder to manslaughter where the defendant was suffering from a mental abnormality.
And a really key procedural point here, the burden of proof is on the defense.
Yes, unlike loss of control. The defense has to prove diminished responsibility, but only on the balance of probabilities, a lower standard than the prosecution's beyond reasonable doubt.
So what are the elements the defense needs to prove? Section 52(1) sets them out.
4 things. 1. The defendant was suffering from an abnormality of mental functioning. 2. This arose from a recognized medical condition. 3. The abnormality substantially impaired the defendant's ability to do one of 3 things listed in subsection 1A, understand their conduct, form a rational judgment, or exercise self-control. And 4. The abnormality provides an explanation for the killing.
Abnormality of mental functioning, what does that mean?
It's not legally defined, but think of it as a state of mind so different from that of ordinary people that a reasonable person would term it abnormal. It links directly to those 3 abilities: understanding, rationality, self-control.
And it must arise from a recognized medical condition. This is a stricter requirement than under the old law, isn't it?
Yes, it has to be a condition recognized by relevant professions, usually meaning it's in classifications like the WHO's ICD or the APA's DSM. The sources list examples often accepted: developmental disorders, depression, Gittins, bipolar, Inglis, schizophrenia, Sutcliffe, brain damage, psychopathy, Byrne, postnatal depression, Reynolds.
Things like battered women's syndrome, Alawalia, or severe PMS Smith, which were accepted under the old law, could still qualify if they're now recognized medical conditions.
Exactly. And crucially, you need expert medical evidence for this defense, usually psychiatrists.
And that Brennan case from 2014 is vital here, right?
Hugely important for exams, Brennan says. If the defense presents expert medical evidence supporting diminished responsibility, and the prosecution doesn't call its own expert evidence to contradict it, then the trial judge must withdraw the murder charge from the jury. The defense basically wins on that point if their evidence is unchallenged by opposing expert evidence.
So the prosecution can't just cross-examine the defense expert. They need their own expert if they want to fight it.
Correct. Now, what about alcohol and drugs?
Always complicates things.
Doesn't it just? Voluntary acute intoxication, just being drunk or high, is not a recognized medical condition itself. Cases like Fenton and Dowds confirmed that. You can't rely on just being drunk at the time.
But what if someone has a recognized condition, like depression, and they were intoxicated?
Then it gets tricky. The defense might still work if the underlying recognized condition itself substantially impaired their ability and provides an explanation for the killing, even with the intoxication mixed in. That's the principle from Deitchman.
So the jury has to disentangle the effects, as in RVK with schizophrenia and intoxication.
Exactly. Kay needed to show schizophrenia, not just the drunken drugs, was a significant cause of the impairment leading to the killing. It's about the impact of the recognized condition.
But there's an exception for chronic conditions.
Yes. Chronic alcoholism is recognized as a medical condition, and it can potentially ground a diminished responsibility defense. Cases like Wood and Stewart confirm this.
So in Wood, the fact he was a chronic alcoholic was key, regardless of whether his drinking that day was voluntary or not.
Pretty much. The focus shifts to the long-term condition itself being the source of the abnormality of mental functioning.
Okay. The third element was substantially impaired. How substantial is substantial?
Good question. The Supreme Court looked at this in Golds, 2014 and 2016. They said substantially means something weighty, important, significant, more than merely trivial, but doesn't have to be total impairment. The impairment needs to have made a real, significant difference to their ability to understand, judge rationally, or control themselves. It's ultimately a judgment for the jury. Let's repeat that. Substantially impaired means significant and appreciable impairment.
And finally, the abnormality must provide an explanation for the killing. Section 52, 1B.
Yes, meaning it caused or was at least a significant contributing factor in causing the defendant to kill. It establishes that causal link between the mental condition and the act of killing. A psychopath, for example, might have a recognized condition, but if it doesn't substantially impair their abilities or explain the killing, the defense fails.
Right. That covers murder and the ways it can be reduced to voluntary manslaughter. Now, let's tackle involuntary manslaughter.
Okay. Here, the defendant has caused death. The actus reus is there, but they don't have the mens rea for murder, no intention to kill or cause GBH. Liability is based on a lesser degree of fault.
And the sources identify 3 main types.
Yes. Reckless manslaughter, unlawful act manslaughter, often called constructive manslaughter, and gross negligence manslaughter.
Do they overlap?
They certainly can. Some situations might fit more than one category. The prosecution will usually choose the one they think is strongest or easiest to prove based on the facts.
Reckless manslaughter gets a brief mention. Requires foresight of death or serious injury.
Yes, but as the sources note, it's rarely prosecuted as a standalone charge. Why? Because if you foresee death or serious injury as virtually certain, that usually tips over into oblique intention for murder. And if you foresee some harm from an unlawful act, it's often covered by constructive manslaughter anyway. So it tends to just be an alternative verdict the jury might consider if murder isn't quite proven, but there was clear foresight of risk.
Okay, so let's focus on the other two. First, unlawful act manslaughter or constructive manslaughter.
This is where liability for the death is sort of constructed on top of liability for a lesser criminal offense.
It's controversial because you can be guilty of manslaughter without intending any harm, let alone death. Right, that classic example. The single punch, illustration 7.7.
Yeah.
Didn't intend serious harm, maybe just a minor assault, but the person falls, hits their head, dies unexpectedly.
Exactly. That's constructive manslaughter territory. So the elements are key. First, there must be an act. Remember low. Can't be by omission. Has to be a positive act.
Second, that act must be criminally unlawful. Not just a tort or civil wrong, Ranklin. The prosecution has to point to a specific base crime, Jennings.
Third, the defendant must have the mens rea for that base unlawful act, Larkin Lamb. And they mustn't have a defense to that base crime, like self-defense, Scarlett.
Fourth, the unlawful act must be dangerous. We'll come back to that. And fifth, the act must cause the death. Standard causation rules apply.
Now, there's a really important qualification about the unlawful act itself from the Andrews case.
Right, this is crucial.
Yes, the base unlawful act cannot be a crime that is only unlawful because it was done negligently or dangerously. Think of driving offenses like speeding or careless driving. Their unlawfulness comes from the manner of performance.
So if death results from speeding,
You can't use speeding as the base unlawful act for constructive manslaughter. If the liability is based on negligence or dangerousness in performing an otherwise lawful activity, like driving, you have to consider gross negligence manslaughter instead. Lord Atkin put it perfectly. There is an obvious difference between doing an unlawful act and doing a lawful act with the degree of carelessness which the legislature makes criminal.
so dangerous driving itself isn't the base crime. But if you were, say, stealing a car and driving dangerously during the theft could potentially be the base unlawful act.
Potentially, yes. If the theft itself, the base crime, was committed via an act which was also objectively dangerous and caused death.
Okay, let's nail down dangerous. It has a specific legal meaning here.
It does, and you really need to know this definition from the Church case, 1966. An act is dangerous if all sober and reasonable people would inevitably recognize it must subject the other person to at least the risk of some harm resulting therefrom, albeit not serious harm.
So, risk of some harm, even minor harm, not serious harm or death.
Correct. Risk of some harm. And it's an objective test what the sober and reasonable person would see, not what the defendant saw. Remember that Church definition. Let's say it again. Risk of some harm, albeit not serious harm.
Applying that Church test to letting tires down, activity 7.11, is the act itself objectively dangerous in that sense? Probably not, right? The danger comes later from driving on flat tires, not the act of deflation itself subjecting someone to immediate risk.
Exactly. The risk has to flow directly from the unlawful act. And the act doesn't have to be aimed at the victim. Mitchell, the post office Q push.
And knowledge matters for the objective test,
Yeah.
like Dawson versus Watson.
Yes. In Dawson, the replica gun robbery wasn't dangerous because the victim's heart condition wasn't known to the reasonable observer. But in Watson, the burglar became dangerous once the elderly victim's frailty was obvious to the burglars, and thus the reasonable observer. The assessment is based on the knowledge available at the time.
Applying Church to the gun example, activity 7.11. A real loaded gun pointed at someone. A reasonable person would likely see a risk of some harm, like an accidental discharge or a struggle causing injury, so probably dangerous. A replica. Maybe not, unless the victim's extreme fear was obvious and that fear posed a risk.
Sounds right. Causation is the final element. The sources mentioned drug supply cases. Supplying drugs isn't usually constructive manslaughter if the victim freely injects themselves. Kennedy noted too, as that breaks the chain. But if the defendant injects the victim, Cato, that is constructive manslaughter, base crime under OEPA is .23.
And for suicide after Dee's Act, the Wallace case suggested a broader significant contribution test might apply now.
A developing area. But let's reiterate the crucial mens rea point for constructive manslaughter. What does the prosecution need to prove about the defendant's state of mind regarding the death?
Nothing. They only need to prove the mens rea for the underlying unlawful act. not that the defendant foresaw any harm, let alone death.
Exactly. That's the rule from DPP v. Newberry and Jones. Throwing the paving slab off the bridge, they only needed the intent for the criminal damage or assault, the base crime, not foresight that it might hit and kill the guard. Let's repeat. No foresight of harm is required for constructive manslaughter liability regarding the death itself.
Which is why it's called constructive liability, and why reformers want to change that Newberry and Jones rule, perhaps requiring awareness of risk of some injury.
Precisely. Okay, last category. Gross negligence manslaughter or GNM.
This applies when death is caused by a defendant breaching a duty of care owed to the victim in a very, very bad way.
Yes, a gross breach. It often applies where someone is doing a lawful activity, like driving, or performing surgery, or managing a building site, but does it incredibly carelessly. Or it can apply to omissions failing to act where there was a duty to do so, like parents neglecting a child. Think illustration 7.1 the anesthetist overdose.
First step is establishing a duty of care. Who decides that?
The judge decides, as a matter of law, whether a duty of care situation exists. If yes, then the jury decides if the duty was breached, if the breach was gross, and if it caused the death.
And duties can arise in many ways: contracts, relationships, statute.
And significantly, from creating a dangerous situation, Mueller principle, which the Evans case expanded upon for G&M omissions. Remember that quote from Lord Judge in Evans?
About creating or contributing to a life-threatening state of affairs.
Yes. When a person has created or contributed to the creation of a state of affairs which he knows or ought reasonably to know has become life-threatening, a consequent duty to act will normally arise. Very important extension of duty for omissions.
And even doing illegal things together doesn't automatically negate a duty, right? Whacker, smuggled immigrants, and Willoughby, arson for insurance fraud.
Correct. Public policy meant duties were still found in those cases despite the joint illegality.
Okay, so there's a duty. Then the breach must be gross. How bad is gross?
It's a very high standard. The leading case is Adamico. The jury must consider if the defendant's conduct was so bad in all the circumstances as to amount in their judgment to a criminal act or omission, its conduct falling far below the expected standard, deserving criminal punishment.
And crucially, the negligence must involve a risk of death, mustn't it? Not just injury.
Yes, that's a key differentiator from constructive manslaughter. The negligence must relate to a risk of death. And a really vital point from recent case law, that risk of death must have been apparent at the time of the breach.
This came from R.V. Rose, the optometrist, and R.V. Kudis, the takeaway allergy.
Exactly. In Rose, the risk of death from the condition wasn't obvious, just from looking in the patient's eyes during the routine check. It required examining images she negligently didn't look at. In Kudis, the risk wasn't apparent without knowing about the specific allergy. So, the serious and obvious risk of death must exist and be apparent at the time the defendant is breaching their duty. Let's repeat that. Risk of death apparent at the time of breach.
Causation applies here, too. The gross breach must have caused the death, Dalloway principle, and for omissions, it's tough to prove.
Very tough. The prosecution has to prove that if the defendant had acted as required by their duty, the victim would have survived. Not just might have, but would have, beyond reasonable doubt, Morby.
Like in R.V. Broughton, the overdose case. Failing to get help, even if there was a 90% chance of survival with help, wasn't enough proof that acting would definitely have saved her life.
Correct. It's a high causal hurdle for omissions in G&M.
And just to recap the roles, judge decides if a duty exists, jury decides breach, grossness, and causation.
Spot on. And finally, the sources note there was a human rights challenge, Amit Misra arguing G&M was too vague because the jury decides grossness after the event. But that challenge failed. The courts upheld G&M.
Wow, okay, that was a comprehensive tour. We started with the common ground, the actus reus of unlawful killing of a human being.
Then we drilled into murder, defined by its mens rea, intention to kill or cause GBH. We looked at direct intent and that crucial concept of oblique intention foresight of virtual certainty, allowing a jury to find intent.
We covered the partial defenses, reducing murder to voluntary manslaughter, loss of control, loss of self-control plus qualifying trigger plus objective test, remembering the rules on suddenness, revenge, triggers like fear or justifiable serious wrong, and the exclusion of sexual infidelity itself. And diminished responsibility, abnormality of mental functioning, plus recognized medical condition, plus substantial impairment, plus explanation for killing, remembering the defense burden, Brennan on expert evidence, and the rules on intoxication versus chronic conditions.
And we finished with involuntary manslaughter. Reckless, briefly. Then Unlawful act constructive, dangerous unlawful act, mens rea for base crime only, Newberry and Jones, church test for dangerousness, Andrews restriction, and finally, gross negligence manslaughter. Gross breach of duty, risk of death apparent at the time, causation rules especially for omissions.
Really understanding those differences, the specific requirements for each offense and defense, those key case names and what they stand for, Woolen, Church, Adamico, Rose, that's absolutely vital for getting to grips with this topic, especially for your exams. Go back, review the definitions, the triggers, the tests.
Definitely. Breaking it down element by element, case by case is the way to tackle it.
Now, we mentioned that challenge to gross negligence manslaughter, the argument that letting a jury decide grossness after someone has died makes the law a bit unpredictable. The court said no, the law is clear enough, but does that idea that conduct might only become criminally negligent after the tragic outcome raise any questions for you about fairness or legal certainty? Just something to think about.
A good final thought to mull over.
Okay, that brings us to the end of this deep dive on criminal homicide. Thank you so much for joining us.
Yes, thank you. And thanks again to the University of London for these excellent source materials, and to our sponsor, Sinorbit Academy, Sri Lanka.
And one last time from both of us and from Sinorbit Academy, really good luck to all of you with your exams and your continuing studies.
Best of luck.
We'll catch you on the next deep dive.